After that is Turcios-Flores v. Garland out of the Sixth Circuit. This one is just great for quotes. It's an asylum case from Honduras. Really just all of the good things that you like to hit in particular social group cases, nexus cases, the difference between nexus for asylum and withholding of removal. The Sixth Circuit is one of those circuits with a lesser nexus standard for withholding than with asylum. Not going to get into all of that. But it's a must read in the Sixth or with any of these cases, and so many asylum cases are like this. One of the countries in, one of the triangle countries in Central America, Miss Turcios-Flores and her husband owned land. MS-13 is making them get a war tax, threatening to kill them because of it. All of that stuff. The husband flees to the U.S. and then they turn to Miss Turcios-Flores and her children. And without getting into all of that and the nexus and the complicated, and it's a very favorable case, highly recommend it. But what is maybe best for the case are quotes like this. Well, before I get to the quote, for a particular social group to be cognizable under asylum law, it has to be immutable, particular, and socially distinct. And so, those are hard in and of themselves. Then if you even establish that it's a legitimate particular social group, you got to show that there's a nexus to the harm, that was one central reason or a reason for the harm suffered here. So preliminarily, just getting over the particular social group, is it immutable? Is it fundamental? And here's the quote: Honduran land ownership is a fundamental characteristic, something that Hondurans shouldn't have to change to avoid being persecuted. That makes it immutable. Honduran land ownership is immutable in the Sixth Circuit. That's a big deal.
Mm-hmm.
And also it goes against the matter of ERAL from the BIA in 2020 with Guatemalan land ownership. So it's a big deal.
Yeah. They're denying these for years, so 20 years they've been denying these, right?
Yeah, I mean, and well, it depends on the IJ. The stuff always it's so, and there's always new cases, and it's so hard to say what is the law. But that's a great quote, and you still need to establish particularity and distinctiveness for Honduran land ownership, but you're over immutability. That's something to always remember in the Sixth Circuit and others. There were multiple particular social groups in this case. Another one asserted was single mothers living without male protection. That's a pretty common one. That we see in these type of cases. And here the Sixth Circuit said, quote, single mothers living without male protection is socially distinct. That's the third element for a particular social group. So if you can show that that's immutable, and quite frankly, I don't see how that's not immutable. I mean, you're a single mother living without male protection. It's probably immutable. Is it particular? That might be a hard one. Who knows? But the Fourth Circuit has great particularity case law, not to get into here. But social distinctions are often one of the hardest element to prove. And here is the Sixth Circuit saying social mothers living without male protection is socially distinct. The reasons are because Honduras distinguishes them. They're as a broader category, vulnerable to persecution. The deputy commander of the Honduran National Police explains that gangs identify vulnerable people, such as women with children, to target. And, that's creative lawyering, and probably present in all of these gang-type cases. I mean, of course, right? Of course the police in these countries are going to say that single women with children are more susceptible to being targeted by gangs. And wherever that is shown, that can be a factor used to show that the group is socially distinct. So big case for stuff like that. Big quotes, a lot more things to go, but, the case is remanded and a lot of other good stuff from that decision for people to look in your asylum cases.
That's interesting. They're opening it up. And in some circuits, they're opening up asylum. Some they're closing. It's just like this, I don't know if amorphous is the right word, but just it's this live thing where one door is open, one door is closed. It's crazy how the circuits are working out on the asylum issue.
Very much so. I mean, even this decision itself, it's a split decision. Judge Chad Riedler essentially dissented. He was appointed by Donald Trump. He was actually head of the civil division under Trump for a bit, which made him in charge of oil. He reads it, comes a completely different conclusions. So like not even you can't even paint circuits with a broad brush. I mean, sometimes it's the panels in either direction. Saw quite a few split decisions over the last month and a half. So I mean, judges have different opinions on this stuff.
Well, look at the sixth. It's like 4 states essentially, and you compare the ninth, which is like this humongous area.
Oh, nine is huge.
Six, I mean, it's Ohio there, but the rest Michigan. I mean, there's not that much population in those areas too. It's interesting.
Don't hate on Michigan. Michigan's a fine state. Michigan's got a
State, but
population.
a lot of people left. I mean, California's leaving. Everyone's leaving here too, but but it still seems small like compared to the rest. But hey, take it. No offense to the Sixth Circuit, Tennessee, Kentucky, Ohio.
Yeah. So that is Turcios-Flores. Great case, must read. Was doing a lot of posting about it on social media with those quotes because they're really helpful. People should know about it. Mm-hmm. And like, Sixth Circuit stuff isn't binding anywhere except the six, but like it's persuasive.
Mm-hmm.
Something to rely on if you don't have anything from your circuit, of course. As a former law clerk, attorney advisor, it is kind of when you get a brief, just for everyone listening, when you get a brief and it's filled with out of circuit citations, and especially for things that are like common, like if you got a brief for the San Diego Immigration Court explaining the 3 requirements for a particular social group, relying on Fourth Circuit precedent, like you can find a million Ninth Circuit cases for the 3 elements. Like it sets off a brief on the wrong tone and makes you look not serious. Just a heads up for brief writing. Like you always cite the in-circuit precedent unless you can't. Unless you're trying to push the circuit law in a certain direction, like the Turcios-Flores decision would do.
Mm-hmm.
I know why people do it. It's because they have their brief and they don't want to rewrite it. They don't want to do more research, and Westlaw is expensive. I get it, but like, the judges, all we can do is speak through our writing. So like,
speaking of Westlaw, is your database open yet? I know you're collecting databases, so how could someone access it to find these resources?
Yeah, they've been on the Kurzban website almost since day one. All of these cases are on the podcast website with a bullet about what they're about. And I make that bullet helpful for me because I go do all the time. So you can do control find on that page, and if you forgot it was Turcios-Flores, you typed in Honduran landowner, you'd find it quick. That's how I'm doing that.
It's a free Westlaw. There you go.
Well, I don't have the case there. Hopefully one day. You still got to find the case, but you can find the case. I read these cases day of free from the circuit websites. So like, I mean, this is all free. It's just harder to get.
Text and Justia, they have all the cases. It's just put the name. Okay.
You just have to know what to look for.